We have file item 12 by Assembly Member Daley. If you could just give me 1 second, sir, before you begin.
Well, I hope the love fest continues. He's thinking about it.
Good afternoon. We're on file item 12, AB 999 by Assembly Member Daley. Good afternoon, sir.
Thank you, Madam Chair and members. I was commenting that I hope the love fest from the previous item continues. I want to begin by accepting the amendments as suggested by the committee. The amendments correct an inadvertent removal of an oversight provision that allows a court to supervise the distribution of proceeds from the sale of an abandoned mobile home. This bill allows landlords to dispose of abandoned mobile homes fairly and equitably. When mobile homes are abandoned, they often have little to no value. Unfortunately, owners of these properties frequently owe back taxes. Under current law, the manager of a mobile home park must pay any delinquent taxes owed by the previous owner in order to dispose of an abandoned mobile home. This requirement is simply unfair, and it can delay or prohibit the disposal of a property which is unsightly or poses a hazard to nearby residents. My bill fixes this problem by ensuring that the delinquent taxpayer remains responsible for the unpaid property taxes. At the same time, the bill maintains existing stringent regulations and judicial proceedings associated with the disposal of abandoned mobile homes. With me today is Catherine Borg, representing the Western Manufactured Housing Communities Association, who are the sponsor of AB 999.
Thank you very much. Please proceed.
Catherine Borg with the Western Manufactured Housing Communities Association. As the author said, we don't change any of the due process guidelines in here as far as how we gain access to ownership of the mobile home, but it's just a matter of if we are going to dispose of this home, we would not be required to pay the back taxes, and they would remain on the books for that taxpayer to pay. Thank you.
Very good. Thank you very much. Any other witnesses in support? Is there any opposition to the bill? Motion by Senator Hertzberg. Thank you for bringing this bill. I think it's going to be of assistance to everyone. And with that, we have a motion to pass as amended to Senate Appropriations. Please call the roll.
Just a question, Madam.
Oh, I'm sorry. I didn't see that. Forgive me.
No question.
I don't want to continue the love fest.
I most apologize. I didn't see you over there. Please.
The owner of the trailer park doesn't have to pay the taxes, but someone does. Are we taking, when you notify the treasurer, tax collector, that you're going to sell the abandoned mobile home and its contents, are you asking the treasurer then to move it over from the secured roll to the unsecured roll?
At the point in time in which this usually occurs, it's already been transferred from the secured roll to the unsecured roll. If the tax has not been paid for more than, I think it's like 6 months to a year, it automatically gets transferred to the unsecured roll. So that's where we're talking about here, is those taxes really have been already transferred to the unsecured roll.
And then you just go ahead and try and find the taxpayer later on somewhere else.
Yeah, and sometimes the tax collectors have had luck in doing that.
And then the DMV, is the Department of Motor Vehicles involved at all of this process?
No, HCD is taken over those fees by this point in time.
Thank you, Madam Chair.
Very good. All right. With that, please call the roll. It is due pass as amended to Senate Appropriations.
Jackson?
Aye.
Jackson, aye. Morlock?
Aye.
Morlock, aye. Anderson? Hertzberg? Leno? Hertzberg, aye. Leno, aye. Monning? Wykowski?
4-0. We'll leave that on call. Thank you very much,
Thank you,
Assembly
Madam
Member
Chair and members. Thank you.
Witnesses. All right. We have up next Assembly Member Bonta. Is he here? No? We are out of authors. We have left Bonta, Bonilla, and Lopez, and Lowe. They've all been called, all right? We'll give them a few minutes. We could lift some calls. If you give me just a minute.
You won't comment? Oh. I got a good night's sleep. I don't know what you're thinking.
We have an author. We have Assemblymember Lopez, who's going to present file item 17, AB 1448. Good afternoon.
Good afternoon. Thank you, Mr. Chairman, members. I would like first to start off by saying that I accept the amendments. Today, I'm pleased to present to you AB 1448. This bill allows Californians to hang in their clothes and dry racks, clotheslines, or similar device. Today, and more people are looking at the different ways to use less energy and to save money. This bill makes sure that residents have the right to dry their laundry outside. This bill not allow for tenants to damage the property and hanging out or the personal space. And here with me, I have two witnesses in support.
Very good. You'll need your mic.
It's just going to be me.
Two witnesses?
Oh, just one.
One witness. I'm sorry. Okay. Good afternoon.
Good afternoon, Madam Chair and members. Ignacio Hernandez on behalf of the Utility Reform Network. We are the sponsors of this measure. Let me tell you how we came to sponsor this bill. TURN is, of course, one of the leading consumer advocates at the CPUC to protect low-income ratepayers in California. But in addition to the work that we do at the CPUC, we also do a lot of work out in the community where we reach out to community members, community groups throughout the state to identify issues that are the challenges that they have. And one thing that we came across is that we still have an alarming number of individuals who are struggling to pay their monthly utility bills. Every month in California, about 70,000 people have their either electricity or utilities shut off. That's 70,000 folks. So it's still a struggle for a lot of individuals. On top of that, we have a lot of individuals who, while they're paying their bills, are still struggling. And the one thing that came up was that there were individuals who were subject to homeowners association restrictions and apartment association restrictions that prohibited them from using clotheslines or drying racks in the private area of their residence. And it struck us that, one, did not make a whole lot of sense as far as what's good for the environment, but for the bottom line, for the pocketbook, for those individuals that are struggling, it created an additional challenge. Not only are they having the challenge of trying to pay their bills, but on top of that, they have the threat looming over them that their homeowners association or apartment association would send them a notice or complaint telling them that they simply cannot use a clothesline or a drying rack. Several other states have already taken action in this area. There are a number of other states that are moving bills very similar to this. It's a growing issue, a growing concern. And when you scratch the surface of this, you realize that we're dealing with real issues, real people, and this is a very important solution. We don't want individuals who are struggling, who want to save money or want to maybe conserve, to worry about facing a complaint from the homeowners association or apartment association. For those reasons, we are the sponsor, and we ask for your support.
Thank you very much. Are there any other witnesses in support? Witnesses in support, if you just step up to the mic, although we do, if you would like to testify, we do have 2 minutes available. I don't think there's any opposition, so you might not need the whole 2 minutes.
I won't take 2 minutes. Danielle Blassett with the California Municipal Utilities Association. We represent energy and water utilities. We're in strong support of this bill as an energy-saving option.
Very good. Next witness, please.
Dennis Garcia on behalf of the Consumer Federation of California and the Latino Coalition for a Healthy California on support. Thank you.
Thank you. Any other witnesses in support? Any witnesses in opposition? All right, as I understand it, this bill does not preclude CIDs from restricting the use of clotheslines in areas of a separate interest like a front yard or in common areas, which I think is a good balance here. And are there any questions? Senator Leno, did you?
Just wanted to say I think it's a terrific bill, and for all the reasons that Mr. Hernandez mentioned, but also as climate change is bringing us longer and hotter summers, it's going to be a great benefit to an already challenged grid. And so it makes terrific sense.
All right.
I move the bill.
Moved by Senator Leno. Senator Morlock.
The joy of living in a condominium is that you get to, or some certain housing areas, is you get to deal with a homeowners association and a board and an architectural committee and what color you can paint the house and what plants, and it just goes on in ad infinitum, and only to get a notice after you've done something to take it down. So, and there's reasons for that. So we're saying that if you put up a clothesline, it's meets standards, so that all of a sudden you're saying community areas are like, I wouldn't be able to put it in a front yard, for instance, so that everybody sees my clothesline.
Right, and if I may, Madam Chair, so just as background, when the bill was initially introduced, we sat down the homeowners associations and a number of other entities were in opposition to the bill. They had a number of questions and concerns because they wanted to have some flexibility to have some reasonable good faith restrictions, much like you said, front yard, other things like that. We have structured the bill in such a way that the associations can still have some flexibility in establishing reasonable time and location restrictions, as well as if there's a device that's perhaps 40 feet tall, or some other, they can have some limits, and so we've struck that balance, and that's why all of those entities removed their opposition, some of which came on in support. So there's still those restrictions. It just says it cannot be an outright ban, and on a good faith basis, they can have both time and location restrictions.
Thank you, Madam Chair.
All righty, very good. Any other comments? We have a motion asking for an aye vote.
Yes, please.
Very good. Please call the roll. The motion is to pass as amended to the Senate floor.
Jackson?
Aye.
Jackson, aye. Morlock?
Aye.
Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning? Wykowski? 4-0.
All right, 4-0. That bill's on call. Thank you, Assemblymember Lopez. And we have Assemblyman Bonta. Is he here? Very good. All right. That is file item 13, the lucky 13. It is AB 1028. Good afternoon, sir.
Good afternoon, Madam Chair and Senators. Today I'm pleased to present AB 1028, which would cure an injustice in current law. Existing law authorizes retired judges in the state of California to administer oaths and affirmations. However, the law currently precludes judges retired on disability from enjoying the same right. Administering oaths or affirmations does not require a feat of physical power or agility. The fact that a judge or justice may be retired for disability because he or she cannot perform all of the duties of a judge or justice all of the time is inconsequential to the individual's ability. Thank you. We think this closes a loophole in existing law. I respectfully ask for your aye vote. I have with me a witness, Judge Richard Bartolini, retired from the Alameda County Superior Court.
Thank you, sir.
Madam Chair, and
Good afternoon, Your Honor.
I am Justice Richard Bartolini. Some time ago, I was retired from my positions as a judge of our Superior Court. That retirement was based on my inability to perform all the duties required of a Superior Court judge all the time. I am and have been a community volunteer for over 60 years. Previously, In December of last year, in November, we had our citywide election, and the new mayor asked me to administer the oath of office, and because of the subject legislation, I had to tell her I couldn't do it. And even more unfortunately, my next-door neighbor received an appointment from the governor as a judge of the Superior Court of Alameda County. She asked me to officiate at her induction, and again, with much sadness, I had to tell her no because of this legislation.
You're just a popular guy. Yeah.
I'm not sure about that. I echo Assembly Bonta's statement that administering oaths or affirmations does not require a feat of physical power or agility, and therefore the fact that I could not physically perform all the duties of the Superior Court judge all the time is not relevant. For no good reason, it appears to punish a judge required for disability from performing a ministerial act. I just want to be treated as all my brothers and sisters who have retired on tenure. This bill received the unanimous support of the Assembly. It is backed by the California Judges Association, which represents over 1,600 judges and subordinate judicial officers. It is also supported by the California Commission on Judicial Performance. I do believe that the material that you've been supplied, I particularly like this paragraph, that the removal of the concurrent disability prohibition would appear consistent with other California laws that protect disabled individuals from discrimination in a wide variety of circumstances. And I just ask for an opportunity to be able to do this ministerial act. Thank you.
Thank you very much. Are there any other witnesses in support? Any opposition? Any questions of the members? Motion by Senator Leno. Oh, he did. I'm so sorry, Senator Leno. Senator Hertzberg moved the bill. All right.
It was a big hint, but it...
I think you're in good shape, and Your Honor, one of the best bits of advice I got when I was practicing law was from a judge who said, you got to learn to quit when you're ahead. So on that, I will call. This is a...
I know of no race won by beating a dead horse.
There you go. All right. I assume, Assemblyman, you are just going to ask for
I
my
vote. Thank you for your consent.
All right. Please do pass to Senate Appropriations. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Wykowski? 4-0.
4-0. That bill's on call. Thank you very much, Your Honor. Thank you,
Madam Chair and
Assembly.
senators and staff.
All right, we have Assemblymember Bonta, who has file item 16, AB 1197. Bonilla. Did I say Bonilla? I said, I'm so sorry. It's getting to that hour of the day. You don't look like Assemblymember Bonta. You look like Assemblymember Bonilla. And it is still AB 1197. All right, go ahead if you would like to proceed.
Yes, thank you, Madam Chair and members. I believe AB 1197 will help protect consumers and uphold the impartiality of court reporters. Thank the committee for their thoughtful analysis. After working with the opposition, I'll be amending AB 1197 to clarify when a disclosure statement is required. 1197 requires the disclosure of ongoing contracts between court reporters or court reporter firms and the parties participating in a deposition. At times, these court reporter firms also provide additional services like trial presentation, strategy advice to aid their client in winning their case. By requiring the disclosure of these contracts, all parties in the deposition will be informed of the potential lack of impartiality and will be alerted that they might also want to seek comparable trial services. Another issue with these ongoing contracts is cost shifting. Court reporting firms offer low prices for contracted deposition services and make up the loss by increasing, or I should say sometimes make up the loss by increasing the cost of copies of the deposition itself. Non-clients have no choice but to order copies from that same court reporting firm. This disclosure will alert opposing counsel to monitor their invoices over time to determine if they are receiving fair pricing. AB 1197 provides a simple and modest solution to the potential issues with ongoing contracts. I have with me today Tony Polone, our legislative chair of the Deposition Reporters Association. And is that Ed Howard leaving? Mm-hmm. Yes, it is. He was here, but he represents DRA.
Been an interesting day.
Can't
Well,
find
ladies
the
and
button.
witnesses, please, in support.
Madam Chair, members of the committee, I am Tony Polone, Legislative Chair for the Deposition Reporters Association of California. AB 1197 is meant to be a very simple solution for an ongoing problem that we've experienced in the deposition world among freelance reporters. Deposition Reporters Association is the largest association representing freelance reporters in the United States, and we have long been concerned about this problem we face of large reporting agencies entering into special deals, arrangements, contracts, if you will, with major corporate litigators who take a lot of depositions and have a great deal of business. They are offering reduced rates to them, often other services, as Assemblymember Bonilla just pointed out to you. And the result of that is that all the parties on the other side in a deposition in litigation are unaware of that relationship, of those special deals, and often, very, very often, are being charged very high rates for the copies that they purchase from those agencies. As any of you who have been in civil litigants before and have been in depositions, you understand that the noticing attorney who takes the deposition is the one that selects the reporter. They may be getting reduced prices from these arrangements that they have with these agencies, and then the other counsel involved in the case, the other parties in the case, are charged excessively high rates for their copies in order to make up for the savings given to the one party, which means litigation is being made cheaper for one side and more expensive for other sides. This is a problem that we believe AB 1197 will very modestly fix by just making it necessary for the noticing attorney who's taking a deposition to also include in his depo notice that there is such an arrangement in existence, or that they have been ordered by their party to require a certain agency, exclusive reporting agency, take the deposition. That is meant to just disclose to all the other parties and their attorneys in the case that there may be a special arrangement here that should be of concern to them. This puts, I think, the fix for this problem in the hands where they belong, in the attorneys and the parties they represent, who may be being treated unfairly, be victims of partiality and of overcharging. And then those parties can, if they see any problem involved, object to the selection of that reporter and insist that another reporter be selected. It's as simple as that. We would thank you, and we ask for your aye vote.
Next witness, please.
Ed Howard, although I should change my name to Ed Humiliated after that. Apologies to Madam Chair and members of the committee. Just briefly, also representing the Deposition Reporters Association, this bill follows the lead of 26 other states, almost all of which have either banned this practice or imposed price caps, as well as a resolution of the American Judges Association, which identifies the problem and specifically calls for the kinds of disclosures embraced in this bill. Thank you.
Thank you. Someone who practiced law, a deposition can be badly or a bad reflection of testimony, and it is disconcerting that there are favorites that can be played and that there are games like this that can be played, let alone with the substance of the testimony that's been incorporated in that deposition transcript. So I appreciate this. I'm not sure it goes far enough, but the bill does what it does, and I want to thank you. I believe there are some amendments that you had agreed to take at the beginning that are reflected in the analysis, and so we'll assume that that is what you're presenting to us. Are there any other questions? Is there a motion? Moved. Is there any opposition? Thank you very much. There is opposition. I'm so sorry. I didn't see you back there. All right, there is opposition. That's why you're here, it's true. All right, here we go. Opposition. I'm assuming that there's no other support, witnesses in support? All right, opposition. Mr. Below.
Thank you, Madam Chair and members. Mike Belote on behalf of a coalition of deposition services companies, including Veritext, Magna, U.S. Legal, and Esquire. There are others, but these groups have come together. In fairness to Ms. Bonilla and her sponsors, we have had ongoing discussions. There have been amendments. The bill is moving in the right direction, and we appreciate that. Respectfully, we would question whether or not there really is a need for adding this to the litigation process. As chair, you mentioned the importance of the accuracy of the record. We are aware of no serious contention that accuracy of transcripts has ever been compromised in California. As a matter of fact, licensed court reporters have a sterling reputation, and if one ever knowingly manipulated a transcript, they'd be out of business. No lawyer would ever hire them again, and so that isn't the problem. The question is the efficacy, efficiency, fairness of these business relationships that do exist between large insurers, large corporations, large law firms who have relationships with our companies. Now, if you have depositions all over the country, you can have somebody in your firm go and find a court reporter each place and find a conference room and do all the work necessary to have the deposition, or you can contract with companies like ours for the efficiency that that brings. And we think it is an efficiency, and that's why people hire us. We use licensed court reporters, the very best freelancers, as Mr. Howard referred to them, and the system is working well. So we would respectfully suggest that the need for the bill hasn't been conclusively demonstrated, but we do appreciate the amendments and we appreciate the spirit that the author and sponsors have brought to the discussion. There's still some minor technical things that we'd like to work with them about. For example, if one of our companies contracts with a court reporter informally and says, we have 3 depositions next week in San Francisco, we'd like you to hire them or handle them. The question is that a contract that would require disclosure? You know, at some point it becomes trivial. Now, if there's a big institutional contract, that's a different thing. But we're trying to work through the detail of this. And again, we appreciate the spirit that the sponsors and author have brought to it. But at this point, we remain opposed.
Thank you very much. Much appreciated. I'd just like to add, the goal, I think, is to maintain the integrity of the process, and this is just a notification measure. So I hope that you will continue working with Mr. Belote. But at this point, we do have a motion. Are there any other witnesses in opposition? Any debate, discussion, inquiry? All right, seeing none, this is do pass as amended to the Senate floor. Would you like to close?
Thank you very much. I would just comment that I think as it is right now in current law, if anyone at the deposition requests that this information be given under law, it has to be, and this just kind of shifts the onus upon the companies themselves to make the disclosure. And so I think it's a more, it's better for the state of California, and reiterate that 26 states actually have far more onerous requirements. Thank you, and would ask for your aye vote.
All right. Do pass as amended to Senate floor. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski?
All right, 3-0, that bill is on call. Thank you, Assemblymember Bonilla and colleagues. All right, we have one bill left by Assemblymember Lowe. He's apparently still presenting in Senate Transportation, where some of our members are as well. So what I'd like to do is lift the calls and see if we couldn't get Assemblymember Holden to return. We've been working with him